91. 2.
Your Lordship has that. While the office of a speaker is vacant, the duties of the office shall be performed by the deputy speaker, or if the office of the deputy speaker is also vacant, by such member of the assembly as the governor may appoint for the purpose. The governor may appoint for the purpose would be on the advice of the council of ministers. And during the absence of the speaker from any sitting of the assembly and deputy speaker, or if he is also absent, such person as may be determined by the rules of the procedure of the assembly.
So one deals with vacancy, second deals with absence.
So, either way, if both of them are absent or for some reason cannot participate, somebody else will be appointed. Right? Now, in this context, look at paragraph 6.2 of the 10th schedule. So, what is it that I am canvassing before your lordships? That there can be no hiatus. Yes. If there's a deputy speaker against you who have given notice, the disqualification proceedings don't stop. That's my first, at the outset I made that submission to your lordship. They've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, is as well as the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided over the house and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the house is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No, the person elected as the speaker then, or chairing the house, will decide. There is no committee.
Read with 180.
Yes. There is no committee. So, therefore, all this not dealt with in Nabam Rebia.
What's the ground for removal of the speaker?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing.
So that was not a disqualification. He was not being removed under
disqualification
under the 10th schedule.
Correct. Therefore, that notice was an ab initio void.
No, but they can always say that, look, we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed your lordship Shakhtar and call, which says it has to be for reason. I showed that to your lordships at the outset. Because removal is stigma, which is why he is allowed to be in the house, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in Nabam. So these are very serious questions. That's another broad point I wanted to make, before I proceed.
Yes.
Anyway, now kindly come to the propositions that I have placed before your lordships. Wherever necessary, I'll refer to the document, otherwise not. Because your lordships have actually gone through all the documents. But first I will deal with item number, page 2, 3 and 4, the submissions made by the other side, which I'm going to deal with presently. At page 2, Roman small 3 and Roman small 4. Their argument was, as your lordships will notice.
Page 2.
Yes. 3 is the respondents have not incurred disqualification under the 10th schedule because their claim is not that there is a split, but that they represent the Shiv Sena. That's their case, which has been decided by the Election Commission in their favor, that there is no distinction between the legislative party and the political party, and the 10th schedule does not stifle the right of the legislatures to dissent. That's their argument. I hope I have encapsulated accurately. Then next 4, respondents have not incurred disqualification under 2(1)(b) of the 10th schedule because the respondents had appointed their own whip, Shri Bharat Gogavle, on the 21st of June, and they have obeyed the whip issued by Gogavle. The legislature party has the right to appoint the whip, relying on members of Maharashtra Legislative Assembly disqualification on grounds of defection rules. I hope, Mullahs, that's a correct articulation of what they've said. Now, Mullahs, our answer, kindly straight away we'll come to the heading, Mullahs. I first deal with the governor.
Why don't we deal seriatim with your submissions actually? Governor, from A onwards.
All right.
That
I can
might be
do that.
better
I thought I would finish the governor first and then.
Yeah, exactly. That is A at page 3. Capital A.
Capital A, yes. A.
Governor's decision.
That's correct. Give me a minute. Yes. It's capital A. Non-recognition of factions under the Constitution. That's the one, Manoj?
No.
Decision.
Page 3, page 3.
Page 3A.
Page 3 bottom, top.
Para 5.
Para 5. Yes.
Oh, okay, yes. Yes, governor's decision. The respondents contend that it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the assembly, and further contend that by whatever process or means the governor can gather the information that was required, which raises a credible doubt as to the majority of a government in power. In support of this contention, reliance was placed on the law laid down by this Honorable Court in Bomai and in Shivraj. That's their case. It is respectfully submitted that the respondent's contention is misconceived and is based on a misreading of the law in Bomai and Shivraj. It is settled law that the governor's decision to call for a trust vote is subject to judicial review, and the same is liable to be quashed if it is based on extraneous considerations. In Shivraj Chauhan, whilst holding that the exercise of discretion by the governor to call for a floor test is subject to judicial review, this Honorable Court observed that, quote, the court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of power. The exercise of such power is not intended to destabilize or displace a democratically elected government, accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of the satisfaction by the governor is not based on extraneous considerations. That's the heart of the decision. It's not Miller's that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships, Miller. Then, Miller, the governor cannot resort to whatever process or means to gather information which casts a doubt on the confidence enjoyed by the government in the assembly. The governor's satisfaction has to be based on relevant and constitutional considerations. In the present case, the governor, in his decision on 28th of June, arrived at his satisfaction that the government headed by Uddhav Thackeray had lost the trust of the House on the basis that, and I quote, majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislature party that they intend to exit from the Maha Vikas Aghadi government. That's the heart of the matter, Manas. That's the decision of the governor. That 34 of them have come to me and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkariya Commission, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any three people from any party will go to say that now you must call for a floor test.
All right, let's read ahead so that we'll get your formulation.
Yes. Firstly, it is respectfully submitted that the resolution of 34 members of Shiv Sena, which is relied on by the governor in his decision on 28/6, does not state that the 34 members intend to exit from the Maha Vikas Aghadi government. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say, Mother, they want to move out of government? Only 8 of them. Thus, the governor has misread the resolution of 34 Shiv Sena MLAs as demonstrating their intention to exit from the Maha Vikas Aghadi government, and consequently his satisfaction about the lack of confidence enjoyed by the government is based on extraneous and irrelevant considerations. Secondly, para 7 of the governor's decision makes it clear that the governor based his satisfaction on a claim made by a majority of Shiv Sena MLAs against the government formed by his own political party, their own political party. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? It is respectfully submitted that the governor has no power to recognize a majority faction of a legislature party, and on that basis come to a prima facie conclusion that the government has lost the confidence of the House. By doing so, the governor enters the political thicket outside the domain of his constitutional duties and facilitates the toppling of an elected government, which is impermissible in law. Paragraph 3 of the 10th schedule, as it stood prior to its deletion, stipulated that where a member makes a claim that he and any other members of his legislative party constitute a group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party, the same would constitute a valid defense in a disqualification petition filed against such members under paragraph 2 of the 10th schedule. Well, my lord asked me this, a question related to this. Well, paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and give that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. And Milord, if your lordship reads paragraph 3 with me for a minute, well, it's very interesting. Original paragraph 3. Statute compilation, PDF page 50.